everyone. Welcome to LexTalk, World Talk Show presented by Clickaway Creators. Today we have Mr. Felipe Martínez Sánchez with us. Felipe has more than 7 years of experience and he focuses his practice in intellectual property matters, mainly trademarks, unfair competition, restrictive practices of competition, protection of consumer rights, and litigation in all of the aforementioned areas. He has worked at multiple Colombian law firms, advising and representing the interest of important national and international companies, primarily in IP and competition law matters. Since September 2018, he works as a senior associate attorney in Ibarra, Rimôn, and currently leads the intellectual property department. Not only this, but Felipe has written important articles which kind of analyzes significant decisions issued in the Colombian legal system, which is absolutely an amazing thing. And not only this, but the articles have been published in highly renowned newspapers in Colombia, if I'm not wrong. So without any further ado, let me just introduce you to Mr. Martínez. How are you, Felipe? How's everything at your end? It's a pleasure to have you on board, and we're really excited to know about you. Please tell us.
Hey, Martínez. Hello, everyone. It's a pleasure to be here again. The pleasure is all mine, so thank you for the invitation. I'm looking forward to this interview.
Lovely. Thank you so much, Felipe. Now we're really excited to know about your journey as a legal professional. Like it's been more than 8 years now, and how did you first of all decide that legal is going to be your space?
We have to back up a few years ago, but the goal for me was always to focus on all the international private matters. I felt super interested in all the intellectual property matters as well as competition when I was beginning with my study at the law faculty. Then I moved on doing some commercial law, deepening at my alma mater in Colombia. I decided this is my path for sure. So I started at that very same time working in a firm very leader in the market of IP. And since then, I've basically non-stop. It's been 7 years now working in IP and competition on a daily basis. Now, with a very international focus, a few months ago, mostly 8 months, we reached an agreement with the firm in which I'm working now in an international alliance with Rimôn, which is a huge participant in the law firms. So now we're part of a global alliance in which we can provide not only the IP services in Colombia and the Latin American region, but also in an international environment. So at this point, we're focusing a lot on copyright, its relations mainly with unfair competition, also with trademarks. At the end, I really enjoy that. Maybe we can, of course, elaborate this further, but for me, it's super cool because I'm not only a lawyer, but I'm also a passionate for music. I play instruments. So for me, it's a very compatible set of work. And it's pretty much like that.
Thank you so much for throwing light on your journey. That how did you actually enter into the legal space and how it has been for you. So, Felipe, I'm going to ask you a very different question because now technology is kind of has already, I would rather speak, has taken over a lot of industries, and we never thought that legal is going to be the one, but it is already happening. So when we talk about Metaverse, because it's kind of a really hot thing which is going on out there. So what challenges poses the Metaverse for the legal industry? We would really like to know your views on that.
Okay, well, good question. I'm very timing at the end. I will say that it's definitely like the trending topic now in the legal industry, on the Metaverse. In general terms, Metaverse is the virtual space that allows people to connect and interact with each other. I mean, this is not only the one from Facebook, from Meta. Its scope goes beyond that. It goes from online shopping until gaming. At the end, you can just create an avatar and live, but in a parallel digital world. This seems like some crazy sci-fi thing if you think about this 30 years ago, but it's a reality now, and it's a reality which involves tremendous amounts of money at this point. And of course, the legal environment keep its pace. So now we of course have multiple challenges. I would say that mainly in the intellectual property space, especially with trademarks, copyrights, also with competition and data privacy. If we take a look, just one by one, as regards to trademarks, this at the end is a new market. So in some sort of way, you are selling or commercializing different products or services. So the main risk now for the companies is what we traditionally call the trademark trolls. Basically, if you consider that the trademark system is one in which it's a first to file right, I mean, if you are the one to apply for the registration of a trademark, you are in a better position than the third parties. Basically, if the companies are not keeping up with what's going on in this particular market, maybe it's the opportunity for trademark trolls to start filing applications and then, of course, blackmailing companies in exchange of their registration. This is not theoretical. This actually already happened to Prada or Gucci, just to say some examples. So with this in mind, companies should take into consideration to develop a strategy, maybe filing new applications in classes which are not their core business. I mean, for instance, class 9, which is mostly regarded to technological service, but now you have computer programs or downloadable virtual goods. Those are in class 9, and you have to consider now to expand maybe the scope of your applications. Many companies in the luxury sector or in the clothing sectors are pursuing this road. Another thing that is gonna have some effects and is having effects now is the non-fungible tokens, the NFTs. This is a huge market. I mean, people are selling the first tweets of their career for $1 million. So we're not talking about minor things. Basically, with this, by means of blockchain technology, you can turn anything into an NFT and sell it. But the problem is, what if the thing you're selling, the thing you're converting to an NFT, is protected by copyright or protected by trademark? Definitely, you may have a potential case of infringement. And again, this is not theoretical. Just last year, finishing the year, there was a huge case, not solved already, regarding Hermes, in which they noticed that some people were selling the famous Hermes Birkin bags, and the NFTs were commercialized for over $1 million. So you can imagine how are the damages for the companies. This as regard to trademarks, but I mean, you can have the same concerns as to copyright. At the end, many art collectors are now moving into this digital space. So we'll have the same problems with digital paintings of digital works, in which you may have reproduction of prior works. So at the end, it's a huge risk, and it's important, of course, to as well as you do it in the, let's call it, regular market or physical market, to conduct all the proper due diligence to assure that you are not commercializing or acquiring things that may be infringing third parties' rights, because you may be involved in some liability. This is to IP, but as I told at the beginning of the presentation, this also has some effects on competition. I would like just to highlight two important things. Now, with these things of the market, when you talk about competition and relevant market, the authorities and the competition practitioners, the first thing that are going to say, okay, let's determine the relevant market by the product market and by the territorial or geographical market. That can become now a bit tricky, because with the product market, you can start making considerations on whether these digital goods are interchangeable or substitutes with the physical ones. How do you calculate that? How broad or how not is your market? And also the geographical market. You can easily find in the Metaverse people from all over the world commercializing goods from all over the world. So at the end, which is your market? If some problem arises, which is the competent court? In the competition proceedings, like in the past few years, the criteria that has been taken is that in digital markets, in most of the cases, you take the competent court where the practice took effect. We'll see if the Metaverse environment follows the same place. And the other thing to highlight is the relationship between data and competition, because okay, at the end, for creating your avatar, for interacting with a lot of people, you are providing a lot of data. And again, the one who owns this metaverse world are huge tech companies which have, like happened with the social media, data of millions of people. That gives you a tremendous power or of market, even a potential dominant position. So the authorities have to keep up the pace of this very evolving world, just to check that we are not facing new potential cases of abuses of dominant position. So just to answer in short your question, we have a lot of new challenges, mainly in IP, competition, and data privacy.
Thank you so much for answering that question. I'm sure that our audience is going to get a different perspective of things, and they're going to gain, some, you know, something out of this particular answer, because it's a very different aspect that you are putting forward. Now, I mean, you have been working in the legal space, and if I talk about particularly in IP for a very long time, and there's this movie, the copyright dispute. I mean, I would like to ask you directly that what do you think about the copyright dispute raised in the Top Gun, the Maverick movie? So can you please throw light on that, on what's your take on it?
Sure, I had a minor delay. Um, yeah, okay. Now nothing has been said. This is a very recent case. We just have the lawsuit filed at the Los Angeles Federal Court. So things are gonna evolve in the following months. But what can I tell you for now? As a matter of context, in the 1983, maybe in the month of May, it was released one edition of the California magazine. Basically, it was publishing this article, very, very famous article called Top Guns by Ehud Yunai. This was very important at the time, and even was considered as the inspiration of the original Top Gun movie. Just as a recap, the one that is being premiered now is the sequel. So the first movie was released in 1986, and it was the inspiration for sure for this movie. Even Mr. Yunai was cited and quoted in the credits of the first movie. So, okay, now the problem is, as I mentioned, regarding the second or the sequel. And this, of course, is not a small fight. Just as a matter of reference, the film from Paramount, if I don't recall bad, but their amount of sales or earning were about 500 or over $550 million just in the first 10 days of the premiere. So you can expect a huge fight on this. But okay, just to get into the details of the case, basically, now who own the copyrights from Mr. Yunais are his widow and his son, Josh and Yuval, and they are suing Paramount Studios, basically under the ground of copyright infringement. They're saying that they have reacquired the rights for producing movie and at the end to utilize the copyright of the article upon 2020. So the discussion is whether they can premiere this and produce this movie in 2022. According to the plaintiff, basically they're saying, okay, this movie wouldn't have happened if it wasn't because of the article written by Mr. Ehud Yunai. So there is some literary efforts and evocative prose and narrative behind all this movie, which of course belong, according to the plaintiff, to the original article. So I would like just to raise two concerns that should be taken into account in this particular case. The first one is that since we're talking about IP and copyright, one thing should be considered is ideas are not copyright protectable. Ideas are not protected by copyright nor concepts. What you can protect with this idea expression dichotomy is the result, the work derived from that idea. So one, for making this assessment, will have to consider if one thing is an inspiration or either is an infringement For addressing this, you will need to determine if the screenplay of the movie poses a reproduction of the original article. It's just a sort of inspiration. These are very different things in which you can maybe talk about no infringement, especially with all the fair use in the United States, which is, we can say, a quite flexible legislation. And on the second point, I would like to highlight that the time is crucial in this case, because according to the lawsuit, they acquired the copyrights on 2020. But it's important to recall that this movie was about to be released in 2019. The point is they have some delays, and again, came COVID and stopped basically the work and also the release of the movie. So the movie at the end was released in 2022. But what is important? What is the importance of this to copyright? In the United States, we have a prior derivative works exception, by means of which, if they have a prior copyright, they could have worked in this project and release it prior to the expiration of those rights. But now the issue is presenting because the movie was just released. So we'll have to see when actually the truth comes out, when they finish the movie, because according to the family, they finished the movie just until 2021 or maybe a couple of months ago. But according to Paramount, most likely they're going to say they finished in 2020. So at the end, we have a trial ahead of us. But the important thing is to consider the idea itself is not copyrightable. We'll see if the screenplay has interaction with the original article or if there is a reproduction, and also when was the time in which the movie was completely finished, because they will set the time frame in which you can enforce this copyright. But for sure, a very, very interesting case.
Thank you. Thank you so much, Felipe, for telling us about your views on this. Now, this is a very interesting question, and this is like one of my favorite questions. That what is a complex legal issue that you have worked on? I mean, anything. I'm sure that there are many, and especially with your experience. But any one case that you would like to talk about, describe the complexity of it.
Sure. Okay. Well, I mean, of course, you understand, for confidentiality reasons, privilege with clients, I'm not in the liberty to tell much details other than the ones are in the public records. But let's talk about this. Some years ago, we dealt at the office with a vulgarization action against a trademark of a major player of the market. It was raised, the first action of vulgarization raised in the world. This is a company participating, I would say, in every country in the world. And this was the first of its kind, which was raised in Colombia. Just as a matter of context, vulgarization is a type of cancellation action that you have against trademarks when they reach certain level of recognizability, in which is so famous, so recognizable, that consumers start confusing which is the product and which is the trademark. So you start calling the product as the trademark, and actually in that vulgarization context, your trademark becomes the generic. One famous case of this is like for instance, the aspirin case in the United States. It was many, many years ago. It was a trademark from Bayer, and it is a trademark in many jurisdictions now. But it was so common that people, instead of calling, I would like this particular medicine by the trademark aspirin, everyone is calling aspirin, and at the end they lose the trademark. So these are huge disputes, because you have to balance basically two rights or two efforts making by the companies. One is, of course, as any company would like their trademarks to become famous. You know, they want to be the most recognizable in the country or in the world. They want that people really notice them in the market. But also, these benefits comes along with a lot of responsibilities, because, as I mentioned, you have to be careful that people don't start confusing them. Not only people, but also all the environment. I mean, the suppliers, the competitors. Everyone has to be certain that you're talking about the trademark. So it's good to have, when you reach this level of notorious trademark, you have to take into consideration that now it's time for developing different advertisements campaigns and different ways of behaving in the market. And one point that will give us like a bit of why is this super important for the companies is that at the end, trademarks are assets. So if you lose the trademark by means of a cancellation, basically you lose an asset. So just to put it in context, if you think about the most famous trademarks in the world, I mean, Apple, Google, Disney. For instance, Apple, its value is over $240 billion. The same goes for Google, who has very similar figures, Microsoft. So imagine not only, okay, you lose the trademark, but you are only losing not only the trademark, $240 billion. So of course, this is a huge fight for companies. Okay, so now we did like landscape of context. We faced this vulgarization action, which was at the end very well structured, and the counterparty filed some polls that try to demonstrate this fact that the consumers were not able to differentiate which was the good and which was the trademark, and it was a mess, of course, for the company, especially because it was the first of its kind. So, okay, we start I will say that it was one of the cases that involved of the firm. So you can imagine a group of 40 lawyers, 40 paralegals working in the very same case. It was huge. And at the end, we did all for the process. I mean, you didn't only focus like in the drafting the document and going to hearings and all that. Now, from gathering the evidence myself, I went to shops, to whatever place, just to demonstrate and try to gather some other piece of information that allow me to demonstrate that at the end the trademark was not vulgarized. Our strategy of defense was saying, yeah, it's true that the trademark is very recognizable, but maybe you are not asking the proper questions, and maybe the polls are intended to mislead consumers. So we raised all our defense from this regard, and also accrediting that the competitors and the suppliers, they all were very respectful of the trademark. No one was saying, okay, I'm going to call this product as the trademark because that would be a proper infringement. And the company was super active taking actions against infringers. So by means of demonstrating these and also another polls as regards to the recognition of the trademark, we managed not only to win the vulgarization claim in the favor of the client, of course, but also to live with a well-known recognition of the trademark, which for trademarks, again, huge. You are having the recognition, the official recognition of the state saying, okay, this trademark has a tremendous notoriety between the relevant market. And also, if we talk about, again, as Bonnie, as companies like to talk about, when you get this well-known recognition, the value of the trademark is likely to increase. So we not only defended that the company remains active as it has, but also increased because of the well-known recognition. And yeah, basically, it was a 24/7 job for a couple of months. But at the end, we managed to turn things on the other direction, and everyone was happy at the end.
Wow, I did not realize that it's going to be that complicated, but it was, and I mean, I'm kind of also jealous of this, that you guys have to, like, do so many things which are so different. At the same time, these are very exciting things. Now, when you look back, of course, I mean, it was a very complex matter, but now when you look back, you must be so thrilled that you've done this, right? So
Yeah, for sure. Super enriching. I mean, when you look back, as you said, it's super enriching for you just to achieve all these things, because at the end, we're lawyers. We can never guarantee that you're going to win a case that's even illegal. But of course, you put all your best efforts to do it. So when it comes to a good end, of course, you are super thrilled.
lovely. Okay. So, as we say, Felipe, that time is money in any profession, but in legal, it's most of all. How do you ensure that you make the best of your time as a lawyer? And how do you manage the personal and professional life, if I may ask you?
Well, that's tricky. I mean, I love the things I do, but sometimes it gets, of course, difficult to manage with with the personal time, because this kind of, especially when you are working in a big law firm and in litigation, it's demanding. And at some point, you will say that it's demanding because of the clients, but you will also notice by experience, I can tell you, people at the end become workaholics. So it's not only that they are saying, okay, you have to work more, or the client is demanding more, but you also want to spend more time because you are getting like sort of addicted to that kind of style of life. But okay, how to manage time? I would say that for me it's a bit easier that for other people is, and maybe that I can now make a link with the introduction I made of myself, because I work in fields that I really like about. I mean, I've been playing the saxophone for many years. I'm a music addict. I go to all the gigs and concerts I can. So even I try to make composition. So when I look at a copyright case, and especially in the music industry, I'm not only focusing in the, okay, the Copyright Act says article whatever, because of course that's my job, but also I'm trying to look it as if I was behind the other side of the table. So for me, it's super enriching because I can actually combine the two of my passions, which are this type of particular law and also the things I like. So at the end, okay, you will say it's demanding, yeah, but things flow because you are combining some passions, and that's at the end, but very good. People say that okay, you find a job you like and you will never work. Of course, that is a cliche phrase and all that. Yeah, but the thing that is a cliche doesn't make it false. At the end, it's true. So I think that is very easy to work and to handle huge amounts of work when you really like that and when you are familiar. Um, Also because, especially in copyright, you see that basically when you are talking with a client, maybe you see the lawyers and they're like super rigid with tie, and from the other side you have a punk band who has been touring for 50 years, not respecting everything. So you have a huge bridge to make. So it's important also to talk the same language. So at the end, when you manage to combine all, the result is good. And for me, make me like do my legal adventures every day more pleasant. And of course, you have to combine not only passion, because no one lives only about of passion, but also with time management. I mean, organization, and of course, teamwork. You can be the most regarded IP practitioner, competition, whatever. I'm not for sure, but I'm trying to be. But at the end, you can be the best example, but you cannot do anything by your side, because it's important to look it integrally and okay, delegate, have a team that can revise your things. For instance, at the office, not even with the most senior person, a document will leave without a second revision, because it's important also to have an opinion, an objective opinion. If you are not critic between your mates, you're not doing a good work, because of course when you are out there in litigation, they are gonna eat you alive. So basically that's part of a teamwork. So have the best strategy at the end when it comes out of the office. You have reached a very good work, and of course it's a teamwork that allows you to manage time best, because this amount of works are huge. So you can of course divide and all, do all these things. So from my perspective, that's the best way to manage time.
Thank you so much, Felipe, for enlightening us with these complex issues that you've worked on, and then your views on the copyright dispute, which was raised in Top Gun Maverick movie. Not only this, but we've also discussed the challenges when it comes to metaverse for the legal space, and of course the time management. So we have done everything in this particular interview, and it was an absolute pleasure talking to you. I'm sure the audience is going to learn a lot from you. And if you have any questions, any follow-up questions or thoughts, you will be knowing about this in the comments. But thank you so much. We would love to have a conversation once again on other trending topics in the legal space. Sadly, we have come to an end of this interview, but it was lovely. meeting you and talking to you about a lot of things. Thank you so much.
No, thank you very much for the invitation, and of course for the viewers, feel free to reach me at any time for any further increase or whatever. I'm happy to help. And again, thank you for the invitation. It was a very pleasant conversation.
Absolutely, absolutely. And at the same time, for our viewers, if you like this chat with Felipe, please like and share this video. Do not forget to subscribe to ClickAway Creators YouTube channel to appreciate what we do, and you have more coming from industry legal leaders like Mr. Felipe Martínez Sánchez himself. This is Bharti for LexTalk signing off.